Let's turn attention to judicial matters. Former Attorney General of the Federation, Abubakar Malami, his son, Abdulaziz Malami, and an associate, Bashir Asabe, have pleaded not guilty to all 16 counts of alleged money laundering and related offenses filed against them by the Economic and Financial Crimes Commission. The pleas were taken at the Federal High Court in Abuja, where the court also refused an oral bail request by the defendants. Mariam Mohammed reports.
At the Federal High Court in Abuja, Justice Emeka Nwite presided over the arraignment of the former Attorney General Abubakar Malami, listed as the first defendant, Bashir Asabe as the second defendant, and Abdulaziz Abubakar Malami as the third defendant. The prosecution, led by E.E. Iheanacho, read out a 16-count charge bordering on alleged money laundering and related financial crimes. One after the other, the defendant pleaded not guilty to all counts. Following the arraignment, defense counsel Joseph Daudu urged the court to grant bail, arguing that the offenses are bailable and the continued detention will amount to punishment before trial. The defense cited provisions of the Money Laundering Prohibitions Act of 2011 and 2022, insisting that the charges were not complex and that the defendants were not flight risks. However, the prosecution opposed the oral bail request, arguing that bail applications must be supported by the affidavit evidence, not oral submission. Prosecution counsel E.E. Iheanacho also maintained that Malami's former position as the Attorney General does not entitle him to preferential treatment, but rather underscores the seriousness of the allegations. After hearing arguments from both sides, Justice Emeka Nwite declined oral bail applications. In his ruling, he held that a substantive bail application had already been filed and that granting an oral request at this stage would amount to unfair surprise to the prosecution, which is yet to respond. The case was adjourned to 2nd of January for hearing of the substantive bail application. Pending then, the defendants are to remain in custody at Kuje Correctional Center.
Of course, we relied on the decision of the Court of Appeal in Abiola and FRN to make this application. But the court, in its wisdom, ruled that the prosecution should be allowed on the circumstance to respond. Bail is entirely at the discretion of the court, and the court, in its wisdom, feels strongly that in the circumstance, the prosecution should respond. Why not? We are pleased with it.
The court is expected to hear arguments on the substantive bail application when proceedings resume January 2nd, 2026. Mariam Mohammed, TVC News, Abuja.
Lawyer Liberus Oshoma joins me now for more on this development. Mr. Oshoma, the Federal High Court in Abuja refused an oral bail request by Abubakar Malami and two others. What does this mean, and what is standard practice for bail requests?
Thank you for having me. Like the lawyer to the prosecutor said, the court is a court of record. This is not a magistrate court where, or a minor offense like misdemeanor, where you can just apply for bail orally. These are the discretion of the court anyway, and for cases like this especially, the court will insist, being a court of record, that application should be filed properly. But however, even the defense counsel had filed an application previously, the day before, according to the prosecution lawyer, that there was a pending bail application and that he's just been served, and that he will need time to respond to it. And on the understanding that the bail application has been filed, I think it was out of place to now begin to ask for bail orally when you know that there is a pending application. But however, the court in its wisdom had said no. Let a proper application be brought before them and let parties respond to it. And the defense counsel cited the case of Abiola, and also the prosecutor's lawyer did say that the case of Abiola was completely different from the case at hand, and I completely also agree with it. So it is not out of place, really. It is standard procedure for lawyers to want to fly kite and find out if they would, if such an application would fly. But the court in its wisdom has said, no, that application would fly. And so it is for them now to come properly before the court.
Right, so with this refusal, yes, Mr. Shoma, so with this refusal, what options are available to Abubakar Malami and the other defendants, and what are the likely next steps?
The option available to them is what they have taken already. They have filed application for bail, pending trial. And the court's matter had been adjourned to take that application and or trial. So the option is pretty straightforward. There is no way that application ordinarily wouldn't have been filed. Immediately plea is taken. The next application in most criminal matter is for bail application, pending trial, pending hearing. And then so that's the option that is available to them. And also at this stage, even though the offense is a bailable offense, it's still at the discretion of the court, even if at the end of the day when the application is eventually moved. All
right, let's talk about the war against corruption in Nigeria. What is your evaluation of government's approach and performance in this regard this year?
Yeah, I think with the optics, the effort, let's first and foremost look at the effort of the EFCC. The corruption in Nigeria had become so endemic that EFCC as an agency cannot really tackle the said, what do you call it, corruption. Because if you ask me, even the EFCC in itself, the chairman had consistently shouted that, there are some members of the agency who also are corrupt. So when you have situations where there's likelihood for compromise and there's likelihood of relationship nepotism, in an organization, certainly you're going to have all of those allegations. And then, secondly, you remember there are so many people in the ruling party today who you can actually point to. And so there were allegations against them, in the EFCC, who today we really cannot say what has happened to their matters. So, and some persons are saying that if Malami were still playing an active role in this government, he probably would not be facing trial today. That's not to say that he's innocent, because there are a lot of Nigerians, I can say about 90% of Nigerians that want to see Malami put on trial because of his antecedent and the way he carried on in the last government, considering the fact that he's a lawyer, a senior advocate of Nigeria, and one of the closest persons to late President Muhammadu Buhari.
Yeah, Mr. Shoma.
People are...
Yes, I hear the foundation you have laid, but you said a statement about the fact that the EFCC as an agency is not able to handle all of what is happening. We also have the ICPC. So what are you proposing in 15 seconds, please?
What I am proposing is that we should actually reform the police. All this job of the EFCC is because of the failure on the part of our policing that you now have to create, two special agencies to prosecute financial crime and independent corrupt practices in government. If we have an effective policing, they will be able to collaborate, and synergize the little effort of these other agencies. But having to look look up to the agencies for corruption cases such as these, it's one very tall order. And you begin to wonder how many, can they really prosecute.
All right, Mr. Shoma, we'll have to leave the conversation there. I've been speaking with lawyer Liberus Shoma. Thank you for your time on TVC News at 7.
My pleasure.
Still ahead on